Uh, I can't believe that it's the end of June. I just remember telling my kids that May was my favorite month of the year because everything is so fresh and so juicy and so green and stuff. And here we are, and it's June 24th, and in a week we're going to be celebrating Independence Day, which is kind of like a midpoint, right? Because there's Memorial Day, then you kind of go to Independence Day, and then boom, Labor Day, and we're back to reality. We're always in reality here, of course. I'm joking, and we actually expanded. We added a new attorney to our team. He's very smart and brilliant, and you all are going to get to know him, and I'm sure you're going to love him as much as you love the rest of our team. We will be making some updates and changes to the website. That all of that is coming. We just want to make it more even better. It's pretty good now, but we want to make it better, right? Once the Facebook Live is over, we also post this video to our YouTube channel where you can, browse everything that I've talked about since March and will continue to be talking about. We try to make it as easy as possible. Every video has a little title to it, but of course I go off script sometimes and I talk about more than one thing, or sometimes I'll tell you I'll talk in the next video about a process, but then some news come out and I want to make sure that I bring that to you. So as promised, today I will talk about what happens to asylum applications when they are referred to an immigration judge. There are other things that happen in immigration court, and we will slowly go through all of them over a very, very long period of time. But today's topic will have to do only with asylum and only for people who are already in the immigration court, right? So how do people end up there? One, people apply what we call affirmatively for asylum, and then go to an asylum interview. And then if they're not granted asylum at the asylum interview and they're out of status, they're referred to the immigration court. That's one way. They're issued an NTA, which is notice to appear, and then they get a hearing notice from immigration court, and the proceedings have begun. Once you're in immigration court, it is called removal proceedings, right? So the easiest way to think about it is you are the U.S. government wants to remove you from the United States, and you are saying, I cannot be removed, I have applied for asylum. That is why it's called defensive asylum filing. You're defending yourself from being removed from the United States. Mostly just having a removal order, right? Because once you have a removal order, commonly known as deportation order, right? Most of the time ICE is not standing outside of the immigration court and waiting for you with your deportation order. Usually it's just a paper, and of course we have people who've lived in this country for decades with deportation orders. So that's not always the case. That doesn't mean that you should disregard these proceedings. They're very, very serious. But there's, as to everything else, there's more than one outcome and more than one answer. Another way that people end up in immigration court, which is very, very common, and we see a lot of it now, is a person come to the port of entry. Most of the time it's US-Mexico border. They come to the port of entry and they're saying, I want to apply for asylum. They're processed, they're given credible fear interview, and then they're put into removal proceedings where their application is defensive, right? Defensive asylum. Another way, which is even more common, people cross the border to the United States all the time. Some people cross the border and have, for decades no interaction with our immigration system. Other people get caught, right, crossing the border. If they're caught, they're detained, and then they can say, well, I can't go back to my home country because I'm afraid, and then they're given credible fear interview. And I'll spend like a whole episode on credible fear because it's a topic of in itself. And if they're determined to be credible, they can then be released from detention, sometimes on bond. Sometimes we have to actually go to the judge and apply for bond. It's called a bond hearing. Sometimes they're released on what's called their own recognizance, means that they don't have to put up any money. The ICE just releases them, right? And sometimes they're released for medical reasons, if they are a child, or if they're under a certain age, there are procedures. And then oftentimes if you're over a certain age, ICE will also release you, especially if it's in conjunction with medical issues. Then you're giving, again, an NTA, notice to appear, and you have a hearing date in immigration court, and then you're in removal proceedings, right? But since you've passed the credible fear interview, you then can proceed to apply for asylum. Okay, as I told you before, asylum is if you're unable or unwilling to return to your home country because you have experienced past persecution, or you are in fear of, you have a future fear of persecution based on one of the grounds: race, religion, nationality, political opinion, and a particular social group. Particular social group is the most vague of the grounds, and there's a lot of case law. It depends what state, what jurisdiction you're in. We recently had some announcements that affected that specific ground for asylum. So the law is ever evolving. There's new law with every administration that comes in, and it changes from year to year, sometimes from month to month, sometimes just from administration to another administration. So you are in front of an immigration judge, you've been served, and a lot of the times you were given, if you were in detention, you were given that paper in person, the notice to appear. It will state the charges against you by Department of Homeland Security, and it will state some basic facts, right? And it will list why they think you are removable from the United States. The first hearing in immigration court is called a master hearing. Pre-pandemic, what would happen is, we would go through with the client as to their asylum or other forms of relief, but we're talking only about asylum today, so I'm just going to refer to that. We'll go through the factual allegations, and then we would go to the court, and it's kind of like a first conference, right? You will know who you're assigned to, the judge. There will be a attorney from the Department of Homeland Security there, and we will go through the factual allegations, removability, and we will tell the judge what you will be applying for. If the package of your application is already ready, we can submit it to the judge, have a brief conversation if there are any other underlying issues, and then typically what happens, the judge will give you a final hearing date, what is called individual hearing. That's like the administrative trial that happens in the immigration court. And every judge usually have their own specifications, certain format of things that they wanted submitted, and a deadline for submission, which every judge could have their own. Some judges wanted it 60 days in advance, 45, 30, 15, which is standard. Post-pandemic, of course, as you know, immigration courts are still closed in New York, and they do not have a firm grip of how exactly they're going to be reopening, although they are reopening right after July 4th, right? So what has been happening recently is that we're getting these scheduling orders, right? You get a packet from the immigration court that says that please submit the following documents and answer the following questions by the deadline, and then the DHS will have their own submission deadline. So they have been doing these in lieu of, instead of the master hearing, which, you know, we like because it is like a court appearance on paper, right? So we get to do the exact same thing, the essence of it is the same. It's just we don't actually have to go to court to see the judge. But if you boil it down to what the process is, it's pretty much the same thing. The same information is exchanged. So these are scheduling orders. I'm hoping they're here to stay, because in 90% of the cases, unless there were serious issues that needed to be discussed with the judge, it was just like an introduction. It was a boilerplate, pretty standard stuff, right? So that's the master hearing. That's what's happening now. It looks like New York will be introducing hearings by video. There will be a system implemented. Of course, just like with everything else, there will be trial and error and developments. Any new system always goes through a very rough period of adjustment with practitioners and the judges and the DHS, because, you know, there are 3 components to a removal proceeding. Well, actually there are 4. There's the judge, there is the attorney from DHS, Department of Homeland Security, and then their act like kind of prosecutor. I don't like to use that word because they're not really prosecutors. They're not there to prosecute you. That is not the mandate of their job, right? But the easiest way, obviously, is to think of it like that. But they're really not a prosecutor. They're representing the government, right? Then there's you, your attorney, and in majority of cases, there's also an interpreter. The reason there's an interpreter is majority of people who are applying for asylum have not been here long enough, do not speak English, and the court needs to make sure that their testimony is given in the most appropriate manner, and the person can give the most detail, you know, and be the most comfortable without struggling to do the translation. You are not allowed to bring your own interpreter. The interpreters are or they're already there. They have been vetted by the immigration court in their interpretation skills. For every language, there's a certain amount of interpreters, and as we practice, you know, we know that, right? If I walk down the immigration court and I see a person, I know that person is an interpreter because I've seen them many times in court and have worked beside them. So the language that is required for the proceeding is disclosed to the judge at the master hearing, or right now in a scheduling order, and the judge's clerk will order an interpreter for the final hearing, because during the master hearing, our clients, you don't really speak. We take care of most of the speaking. At most, the judge can ask, like, what's your name, or like, where you live, where is this your attorney, and very few judges would actually have an actual conversation with our clients during the first introductory hearing, right? That's why I actually like scheduling orders so much, because you don't have to take the day off. You don't have to sit there for 2 hours waiting to not speak to the judge, and since everything happens kind of in the legal realm, it's much easier for me to communicate with judge and the government attorney, because you weren't really participating in those hearings anyway, right? So it would simplify things a lot for us, while still allowing us to do our job. When it comes to asylum, a lot of people misuse or misunderstand what the asylum was intended for, or what kind of benefits are in applying for asylum. you can be afraid to go back to your home country for a myriad of reasons, and not all of them would qualify you for an asylum, right? So it is a conversation that happens at the beginning of the case, where you can have to be brutally honest with us, because we're the ones who have to determine whether you can apply for asylum. And then you have to understand that because the immigration system is so backed up, at the last communication with the immigration court, the backlog is 1.3 million cases. 1.3 million cases are the backlog in immigration court. That translates into years and years and years of waiting. You have to understand that a typical judge will have 2-3 hearings a day of asylum. Each hearing can take anywhere from 30 minutes to 4 hours. We've had that as well. So let's say they're saying they will be adding immigration judges, but let's say there's 35 times even 3 hearings a day times 4 days a week, because one day is dedicated to what used to be dedicated to those master calendar hearings, right? That doesn't translate to big numbers. Often the times cases are not finished the first time around. Judge wants more testimony, judge wants more documents, sometimes interpreters don't show up. Sometimes there are other issues in a case. Sometimes judges want supplemental briefings. So it's not like judge heard 3 cases, issued 3 decisions right then and there. So 1.3 million cases is a huge backlog for immigration court. And what happens is, because immigration is federal law, let's say the way that cases were handled and the attitude of the administration under Obama changed drastically when Trump took office, which actually made few types of cases that were viable under Obama not viable under Trump. There was just no way forward on those cases under the Trump administration, because the law was changed, and the eligibility for asylum was affected under that administration. Recently we had a reversal for a majority of those things, and now those people who were denied under Trump, their eligibility is now again viable. So I'm sure a lot of those people will be filing some sort of relief, because if the only reason they were denied were due to the fact that their cases, their types of claims, quote unquote, didn't have an avenue for relief, and now they're due, those people will be filing some sort of applications, and that's going to create even more backlog, because judges don't just hear cases, then they have to look at it. They have to issue decisions based on current law. Judges also deal with motions to reopen, motions to terminate, motions to recalendar, motions to reconsider, joint motions to reopen. They don't really deal with more than procedural way. So there are other things that happen in the background except for that one interaction that we have with the judge. So all of that is very, 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 very lengthy process. When I just started as an attorney, you could go in a year, right, from a master to a final decision, and those days are gone. We're looking at years. People have been in proceedings 5, 6, 7, 10 years. We have those cases where people have been stuck in immigration court for one reason or another for 10 years. And during those 10 years, things in their case change. So we may have started out with asylum, and then it might have reverted to something else, and then we're pursuing that. So for majority of people, their situation is flexible and can change from administration to administration, and also can change because of their life, right? People get married, people have kids, people have losses, people get divorced. things overseas change in their home countries. Maybe the reason they can go back was because of political opinion, that they were in opposition to a party, and then the regime changed, and the party that was in opposition now is in control. Well, their grounds for asylum have just disappeared because you have no longer afraid to go back. So all of that becomes very, very complicated. So just briefly about the actual final hearing. The individual hearing is when we submit the final packet of documents, your individual documents, as well as what's called background conditions, that describes macro climate in your home country, and describes the geopolitical sometimes describes the more local things that are happening and how that supports your claim. There are times when we use actually an expert opinion. There are people out there who we can reach out to who can even sometimes testify in court, and they provide, let's say they're a professor who spent their entire life studying a particular region, a particular custom, a particular religion, interaction between two particular countries or groups of people. We can ask that person to submit a written opinion that would also further support your claim. We come to the court, the doors are closed. Nobody except the judge, the Department of Homeland Security attorney, me, or one of our attorneys, you, and the interpreter is allowed to be in court at the time. The proceedings are recorded, right? So later on, you can get a transcript of those. So you do get a transcript if you appeal the judge's decision, if either side appeals the decision. And there is kind of an administrative mini trial in a way that you're asked questions, you get to answer them, but also the government attorney and the judge get to ask you questions more than one time, right? So a lot of it is very flexible, and things can progress anywhere from 30 minutes and going into hours and hours and hours, depending how complicated your claim is, depending how many witnesses you've brought, because you're allowed to bring witnesses to your hearing, and they would be seated somewhere outside of the court because they're not allowed to hear your testimony or what happens in the courtroom until it's their time. And when a witness comes in, sometimes the client will be seated in the back, sometimes they will be outside completely, allowing the attorney to question, and the government attorney and the judge to question the witness, right? Sometimes the judge will make a decision same day. Sometimes the judge says, well, you know what, I have to ponder upon this, I have to think about it, I don't know, I can't make my decision. That's when we can ask the judge if the judge would like us to submit more documents, or submit more legal arguments, or the judge may be like, well, I'm not sure about this one specific issue, so counsel, which is us, could you please provide clarification, and then the Department of Homeland Security gets to answer. See how much fun all of this is. Right, and then when the judge makes a decision, there are two types of decision. Short decision, which means the government does not object. That means usually that's a grant, and the judge says, I'm going to grant this person asylum, and let's say the government says, well, okay, we don't object, and then the judge issues a one-page decision. It's short. That means neither side is appealing the judge's decision. And then there's a long decision where either, let's say the judge says, I'm granting asylum, and Department of Homeland Security says, we disagree, we reserve the right to appeal. Then the judge has to issue a long decision, state all of the reasons for why they want to grant the case, and then the government has 30 days to appeal, right? And we'll go through the appellate process in one of the next videos. Sometimes the judge doesn't grant the asylum, they'll deny it, and then our side gets to say we're going to appeal, and the same thing happens. The judge has to give a long decision, state all the reasons why they're denying the asylum case, and then we have 30 days to submit the appeal of the judge's decision. If you've applied for asylum during the entire pendency of the case, so from the very beginning until the very end, you can have work authorization and you can keep renewing it every 2 years. And then at the appellate level, I'll tell you what happens with the immigration, with the work authorization when I talk about that procedure, right? So this is just a brief overview. There are always variations, and there are a myriad of things that can happen. There could be more than one hearing, there could be more than one claim, there could be more than one way to move forward. Sometimes there's more than one thing that we can apply for. So every case is different, and I always tell you, please contact an attorney. Only an attorney can appear in immigration court or an actual designated representatives, and there's not that many of them, to be honest with you. But of course, an attorney is advisable because, you know, there are always, especially nowadays and going forward, there are a lot of legal issues that have to be briefed. It is more complex than just have somebody come with me to court, tell the judge my story, and then get a decision. There are very nuanced issues in every case that we have seen in the past, a trend arising in the past year or so, and I think it's going to be continuing for the foreseeable future. There's going to be a lot of writing, a lot of writing in immigration court across all possible cases. So it is in your best interest, of course, to hire an attorney, to talk to an attorney, at least to consider your options. And there are judges who will very strongly let you know that you need an attorney to proceed. Although you can proceed pro se in anywhere, right? You can argue pro se in front of Supreme Court. You can do this by yourself. Now the question becomes how competent and how much time you can dedicate to doing your own case, knowing that an attorney probably spent years and years and years researching the issues and having experience with the judges in Department of Homeland Securities and the intricacies of the immigration court. All right, I'm gonna stop right now because I feel like this is a lot, and there's a lot to digest. I'm glad that you can actually rewatch this and send me your questions if there's something that you want me to concentrate on, or something that you want clarification on, or if there's a topic that you're like, oh, I can't wait for her to talk about it, and you really want me to talk about it, send me here or on YouTube or through Facebook or through any other means, our website, call us, and I will definitely talk about whatever it is that you want to hear about, because this is, of course, is all for you and about you. If you go to YouTube, you can subscribe. This way you get a notification every time we post a new video. There's a batch of 3 videos that's going to be posted this week or early next week. This is going to be posted around Tuesday of next week. So as always, I wish everybody an amazing rest of the week. I cannot believe it's the end of June. So scary. Please enjoy the weather. Please enjoy your time with family and friends. This is the best time to be out. Get some vitamin D, get some fresh air, especially after the year that we had indoors. It's good for your mood. It's good for your health. It's good for everything, because ultimately, if you're healthy, then the country is going to be healthy, right? Because everybody gets to work and contribute to our society, go out, spend some money, go to a restaurant, try something new. It's one of the best ways to break a bad mood, right? To go out and have a new positive experience. I can't wait to see everybody back here next Thursday. Thank you for watching, as always. Have a great rest of your week and a great weekend.